The Honorable, the Supreme Court.
Morning, everybody. Thank you very much. Please be seated. And if you would, call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled In Re Appeal of S.C.M., case number 24 AP 298. Representing the appellant, S.C.M., is Carrie Johnson. Representing the appellee, the Department for Children and Families, is Zachary Martin.
Okay, good morning, counsel. We'll hear from appellant first. Please come on up. And if you would, for the record, introduce yourself, identify your client, and then proceed.
Thank you and good morning, Your Honors. May it please the court. My name is Carrie Johnson and I'm representing the appellant, SCM.
Thank you.
This case began with DCF's decision to substantiate an allegation that SCM placed a child at risk of sexual abuse merely by being present while his husband babysat for the child. The evidence showed, and the trier of fact found, that SCM was never left alone with the child and was never otherwise unsupervised with the child. In fact, there was not one, but two responsible adults supervising the vast majority of the contact between SCM and the child. And there was at no point where SCM was left alone with the child without at least one other adult.
Do you think the
present.
size of the apartment, which I understand was, is it 700 square feet?
Yes, Your
Do
Honor.
you think the size makes it more conducive to supervision, or does it make it more conducive to an opportunity to engage in sexual?
I believe it is the former, Your Honor. I think the size of the apartment and also the layout of the apartment, it's essentially two rooms. It's one bedroom and there's a living room kitchen area. When on the limited occasions that the child spent the night, he was sleeping on the sectional sofa in the living room with SCM's a guardian. SCM had a court-appointed guardian, and she was living at the time with SCM and his husband, and so she was present during. She testified she never spent the night elsewhere.
Do we need to even get to the supervision issue? In 4912.14, it defines risk of abuse, sexual abuse, and other things. And then in 14F, right before 14F, it says including as a result of, and then you've got the supervision question. And I read that as meaning that is an example of what will satisfy the 4912.14 definition. So if we just find that there is a serious danger that the child would suffer harm, which would be likely to cause sexual abuse, can't we just consider that? Do we even need to get to the supervision issue?
Well, Your Honor, I think when, in order to substantiate risk of sexual abuse, DCF has to prove two elements. And the first element is that this person poses a current risk to this specific child. And the second element is that there is an opportunity for this person to sexually abuse the child. So the person has to first pose a risk and then have an opportunity to sexually abuse the child, because no sexual abuse occurred. And so when we're talking about risk of harm, there has to be a significant danger. It cannot just be a speculative danger.
I don't mean to interrupt you, but so are you agreeing with me that we don't need to consider the supervision aspect of this? But that what you're describing falls under 1412.14 itself, the ability, able to be near the child.
Respectfully, Your Honor, I think supervision is an element of the second thing that DCF has to prove. They have to prove that the contact was unsupervised, because otherwise DCF could substantiate anybody that it's previously substantiated for sexual abuse every time they go to the grocery store and they're near children. And that would so dramatically expand the scope of DCF's reach and also be, it's really vague to the point of unconstitutional when you don't limit the ability to substantiate somebody based on whether the contact was supervised or unsupervised. There were two responsible adults who were supervising the contact here. DCF had plenty of opportunity to introduce evidence that the supervision was inadequate, and it did not do so. The government has the burden here. The government needs to prove that SCM posed a risk first, and then it needs to prove that he had an opportunity to be alone with this child and to perpetrate on the child. Because
I'm all set, yeah.
Can I ask you something about the record?
sure.
So I'm a little, I think there's some ambiguity in the record as to whether or not your client ever completed sex offender treatment. You've got a letter that I saw from, I forget exactly who it's from, who says that he completed, I think, something like community-based sex offender treatment. The state, in its brief or in the supplemental printed case, asserts that your client never completed sex offender treatment. And I think I saw somewhere that he had registered for it but not completed. Can you clarify this for me?
Of course, Your Honor. Yeah. So I think the confusion is stemming from the fact that this report came into DCF in, I think, July of 2020. And so my client had been on probation in July of 2020 for less than a year. And at that point, he had completed the intake at least. The evidence showed that he had completed at least the intake and had enrolled in the treatment. And by the time of this due process hearing in front of the Human Services Board, it was almost 4 years later, and he'd completed it the previous year. So he started in 2020 and he completed in 2023.
So I don't have the date of the Human Services Board decision in my notes here, but so the statement they make in their decision that he had not he failed to complete sex offender treatment and concealed his access to the child from his probation officer.
It's incorrect that he failed.
Those two, one thing is incorrect. The other is accurate. Did he fail to disclose?
He did not get prior advance permission for his husband to babysit the child from his probation officer. And so there was a violation of probation that was filed. However,
But the sex offender treatment, he did complete.
he did complete that, not before. He hadn't had time to complete it at the point that this investigation occurred, but he did everything he was supposed to do. He's no longer on probation as of this hearing.
So what do you say about his failure to disclose to the probation officer? What's your position on that?
I would argue that it's not relevant because the legal standard is not whether he told his probation officer. The legal standard is, does he pose a specific risk currently to this child, and was he unsupervised?
Well, isn't truth-telling foundation element of that?
It may be a factor that can be considered. It is not an element of proving risk of sexual abuse. The government's burden is to prove that there was a risk. And so in this case, the risk was based on a very old substantiation from 2006. That substantiation was never proven by a preponderance of the evidence. It involved over-the-clothes fondling of an almost 13-year-old female. That child alleged that there were two witnesses She claimed that my client also touched those two other witnesses. Those two other allegations involving those two other girls were unsubstantiated, but we were denied discovery on that. I believe that discovery, I think there's a strong inference that can be made that that discovery would have been exculpatory and would have undermined.
That's something we can't be looking at though, right? Whether that process was appropriate or not. I mean, that's not before us.
I think that's a legal question that this court needs to decide is what does the department have to prove when it wants to substantiate somebody for risk of sexual abuse? It does have to prove that there is a risk.
Right, but if they're already substantiated and it wasn't appealed and that substantiation remains, we don't go back and undo that.
I think the important thing to note about that substantiation is that it was upheld under the unconstitutionally low reasonable person standard. Now, when DCF substantiates somebody, they are supposed to use the preponderance of the evidence standard. Reasonable person standard allows a substantiation to occur against the weight of the evidence. So it can be more likely than not that the person didn't do anything.
Did that get appealed after the substantiation, that issue?
He did not get notice of this substantiation in 2006. It looks like he had an attorney who helped him appeal at the administrative level. I think this is, I don't know if this is in the record of this case or not, but administrative appeal in 2018. So he did the Commissioner's Registry Review Unit appeal, which also used the reasonable person standard. I don't know why, but his attorney did not request a Human Services Board appeal, which is where the preponderance standard gets applied. So this was it was never proven by a preponderance. And that's part of my argument here is that if you want to use a substantiation, you need to at least have a preponderance of the evidence that that conduct occurred.
Ms. Johnson,
No, go ahead.
Ms.
Justice
Johnson,
Thorne.
would you agree that the standard of review here is abuse of discretion?
No, Your Honor, not entirely. So I
At least to-
would
At least to the facts?
to the legal questions, I believe the standard of review is de novo. As far as whether the findings of fact, it's a preponderance case, so is the sum credible evidence
But how does the
standard?
credibility issue that was put in the decision factor into an abuse of discretion? So the board found there were some credibility issues regarding him sleeping in the truck, his disclosure, a few other things that was discussed in the decision. And how should that factor into our decision as to whether or not there was an abuse of discretion?
So I think that the key evidence presented was not whether he was initially honest. I mean, he was looking at a violation of probation and, being sent to jail, and people do what they do when they're facing those kinds of consequences. The evidence presented at the hearing, this is a de novo hearing in front of the Human Services Board, and so the evidence that was presented at this de novo hearing was testimony of two adult witnesses, the two responsible adults who were supervising all of this contact. They both testified that they never left SCM alone with the child. They testified that he was never out of their sight with the child, and they testified that he had never created any opportunity to try to be alone with the child. So there just wasn't an opportunity for any sexual abuse to occur, even if you were to determine that he posed a risk to this child.
Ms. Johnson, I have two questions for you. The first is, was the VOP dismissed?
I believe the VOP was
That was my
dismissed
memory from
because
the
there was a
record.
modification
Right,
of his
The conditions.
conditions to clarify. His initial condition was no contact with female children under the age of 16. The child in question was male identifying, biological female, but a trans male who presented as male, used a male name, and looked male.
And does unsupervised require being alone?
I believe unsupervised requires being alone, or it would require the government to show some reason why the supervision provided, the eyes-on supervision, sharing this sectional sofa, with another adult who wakes up and is a light sleeper, and all of the facts that came out in this hearing, why that's not adequate. Where was the opportunity? It's not it's not SCM's burden to prove that he's not a risk. It's the government's burden to show that he is a risk. And if they're claiming that the supervision wasn't adequate, nobody's arguing that there wasn't supervision. The parent argument is that the supervision wasn't adequate, but there was no evidence of that.
And the standard is clear and convincing evidence, correct? Clear and convincing evidence that that he was unsupervised. Is that the standard for the government?
The government has to prove by a preponderance.
Okay, all right.
That he was unsupervised.
Okay.
And in this case, the board added a finding that was just speculative. There was no evidence that he could have been alone. The two adults were very clear that they were doing this to protect SCM from allegations, and that they both were aware of his history. One was his husband, the other was his legal guardian.
Right, okay. Thanks.
Thank you.
Thank you. We hear from counsel for the appellee. Come on up, please. And if you would, for the record, introduce yourself and identify your client.
Thank you. Good morning, Your Honors. My name is Zach Martin, and I'm appearing for the Appellate Department for Children and Families this morning.
Thank you.
Thank you. Your Honors, this court should affirm the board's order. It was properly based on the facts found by the hearing officer, and it was based on a reasonable interpretation of the term unsupervised.
By the hearing officer? The hearing officer found for the respondent.
Correct, Justice Cohen. And the board based its conclusions and decision on the facts found by the hearing officer. In its decision, the board specifically noted at page 14 of the supplemental printed case, and this is footnote 6, that its decision was made pursuant to Fair Hearing Rule 1000.4 subsection F. And that rule states that upon considering all of the facts and arguments, in the case the board may adopt the recommendation of the hearing officer or reject it and reach different conclusions on the basis of the evidence at hand.
But it's de novo, correct?
The hearing,
From the hearing officer to the board.
the board must adopt the facts as found by the hearing officer unless good cause is shown for disregarding them, Your Honor.
Thank you.
And
I have a question for you about supervision.
certainly.
You say that the supervision here was inadequate. What would be necessary in order to make it adequate?
So, Justice Eaton, I think that the board's broader interpretation of what supervision required appropriately furthered the remedial purpose of the Child Abuse and Reporting Act. At least once before, from the research I could conduct prior to today, a panel of this court has endorsed a similar interpretation of what supervision requires. There's a 2003 panel opinion. It's State against LaPlante. The citation is 2003. Westlaw 257-45422. And in that case, the defendant's contact with the children in the presence of adults who were not fully aware of his background could not possibly be construed as supervised contact. And I think that's similar to the situation we have here. For example, the appellant's friend / partial guardian was not fully informed because she really only had appellant's perspective as to his past conduct. If you look at the transcript, page 35 and 36 of the March 29th, 2024 hearing transcript, she testified that the appellant, per him, supposedly brushed up against the girl's breasts and filed charges on him, but that became null and void because she said it never happened. That was in reference to the substantiation from 2006. And then regarding the case that was originally charged as a sexual assault, she stated that the appellant said that he was charged with having sex with a college student in the bathroom, and that there was no evidence to support that. So I guess what I would say in terms of the adequacy of supervision is that the board took a view of what supervision requires as people who are informed and understand the risks. And this court has previously recognized in other contexts related to children the significance of who is there to help a child. It can't just be someone. For example, in the delinquency context, this court has developed the interested, informed, and independent adult rule related to the questioning of children suspected of delinquent acts by law enforcement. They have the right to consult with such an adult prior to waiving counsel or prior to waiving their right against self-incrimination. So this court understands that it matters who is there with a child in that other context. And the board drew an analogous conclusion here, that it mattered who these other adults were in the room.
Can I ask the same question I asked appellant's attorney?
Yes.
Do we have to get into that issue of supervision, or does the overall description of what is a risk of harm, is that something we can consider in and of itself?
Thank you, Justice Carroll. So I think that the court could affirm on an alternative ground, having considered all the evidence, if it found that the record, as outlined by the board's order, supported a risk of sexual harm to this particular child. So I think Attorney Woolard in our brief sort of outlined some of the legislative history related to this, I believe it's 7 different specific circumstances under which risk of harm is essentially automatically proven. This being one of them, the unsupervised time with a child by a convicted sex offender or a registered sex offender or a person who's been substantiated for past sexual abuse. But that's a non-exhaustive list. It's illustrative. It's including, it doesn't say including but not limited to in the statute, but I think in the associated regulations it does. And so this court could, if it found that the facts were adequate to support risk of harm to the child, find that without.
So, Mr. Martin, doesn't risk of harm, however, require a significant danger? Doesn't that mean significant danger?
It does, Justice Waples, and I think that's why the unsupervised is just the more straightforward way that this court could affirm if it wanted to affirm the board's order here.
Was there any evidence to show that there was any time that this child was unsupervised with the appellant?
No, Justice Cohen, and I think that's not disputed, that there's no affirmative evidence to show that the child was ever alone with the child.
So where's the risk then, sir?
Well, I think if the facts as found by the board are taken as a whole, it's a reasonable inference that there would have been a risk. The appellant.
Because of why?
Pardon?
Because why?
Well, because of the appellant's history of having substantiation for sexual abuse of a 12-year-old.
2006, he had a substantiation for an event with a girl, 12-year-old, and he had the event, the prohibited acts in 2019. So based on those two alone, we can make an assumption that there's a risk analysis sufficient to substantiate the appellant?
I don't think it's just that, Justice Cohen. I think it's also the credibility findings that the hearing officer made and that the board adopted in terms of I think what the board ultimately characterized as concealment. That is relevant to showing consciousness of guilt is probably not the right terminology, but I think non-accidental conduct is what the language that the board used.
But Mr. Martin, didn't the hearing officer find, she found the witnesses credible? And in fact, she made the decision that this was unsubstantiated.
The hearing officer made that recommendation to the board based on, I believe, primarily her narrow interpretation of what unsupervised was. The hearing officer at multiple times, and this is it, one example is pages 8 and 37 of the supplemental printed case. Page 8 is the Human Services Board order, and page 37 is the hearing officer's recommended findings. This is at footnote 4 in both documents, indicated that although petitioner's friend testified she was not present during the phone call, did not speak with the DCF investigator, the investigator's testimony was credited over that of petitioner's friend. Similarly, pages 11 and 39 of the supplemental printed case, that's the board order and the hearing officer's recommended findings. Similarly, petitioner's statements made in the course of the department's investigation are inconsistent with the mother's testimony as to his knowledge of the child's assigned gender at birth and are not credited. Petitioner's statements that he slept in his vehicle or at a neighbor's home when the child spent the night are contradicted by his husband's testimony that he did not sleep in a car. And these inconsistencies matter because, as this court has previously held, a defendant or probationer's own implausible or inherently contradictory evidence or explanation of events can corroborate the state's case. And here, the hearing officer made adverse credibility determinations. She didn't find the appellant's evidence to be very credible. And I think, but for her narrow interpretation or reading of the word unsupervised, she may well have recommended that the substantiation be upheld or affirmed.
Can you answer the question that the Chief Justice asked, and I'm still a little unsure? By the time of this substantiation, the petitioner had signed up for sex offender treatment. Had he even started it by then, or was he partway through? What's
Justice Carroll, that's a great question. I think that the evidence was, per the probation officer's testimony, that he had completed an intake.
Yeah.
And I don't think it's disputed that he did complete sex offender treatment in 2003. I think there was a letter of completion that was submitted to the hearing officer. But for purposes of this case, that cannot affect the analysis as to whether the substantiation was correct at the time, because it's a backward-looking inquiry. It's whether DCF's decision to substantiate was supported by a preponderance of the evidence at the time that it was made. Otherwise, I don't have the citation for this case in front of me, but there is a case that talks about how otherwise the substantiation decisions would be subject to constant revision later, and a substantiation would never be final. The fact that petitioner or appellant subsequently completed sex offender treatment 3 years later, that could be relevant to a petition to expunge his substantiation if he wanted to do that going forward. It could also be relevant in the event there were a new Chapter 49, investigation that were initiated, because it would be a mitigating or a protective factor. But it can't affect what the risk was at the time this occurred back in 2020.
How much deference should we give to the mother's testimony that she was fine with the situation?
Your Honor, I don't believe that there were really many credibility findings made as to the mother either way. I don't think that the hearing officer or the board really said, we believe, mother or not. So I don't really know how to answer that question.
Well, it's just that the mother did testify that she thought the situation was fine for her child.
Right.
And she was not the least bit concerned about the child being at risk with the couple, and that the child actually thrived well in the company of the 3 adults.
Right. I think the concern and the risk of harm are not necessarily mitigated just because that's what the mother believed. I think in looking at the mother's testimony during the March 29th hearing, she had sort of expressed a similar view as expressed to her, I think, by the appellant as to what had occurred in his past. I think she had his side of the story in terms of, what had gone on for him. And so I don't think that she was necessarily fully informed in terms of, assessing whether he was a safe person to be around her child.
Is that in the record?
I believe it's in the transcript of the March 29th, 2024 hearing transcript. If I can just have a moment. They called her first in the order, I believe. So
Then they called the mom, and then they called the doctor.
right, yeah, that's right, Justice Waples. They called the doctor on a separate day.
Right.
So So this is, I'm looking at page
Mhm.
10 and 11 of the March 29th transcript. And the mother indicated that the appellant had always been honest with me. And then, so there was some questioning about her understanding of what it was that he was on probation for. And she indicated it was, her understanding was that he was on probation for inappropriate touching of a female child, which was actually of course, the 2006
Right.
substantiation, not the more recent
The
case.
19-year-old, right.
Right. The 18-year-old college student. And then she was also asked if she knew what a substantiation was. And then she said, it means being, no, I actually do not. And this was on direct examination, I believe. And then she was also asked whether the appellant ever disclosed any other sexually harmful behaviors in his history that didn't result in a substantiation or a conviction. This is on page 11. And she said, yes, like I said, this appellant has always been honest. And when asked what else he disclosed, she said, like I said, I can't remember off the top of my head, but there was conversation in the past about stuff. And she was asked to be more specific. And then she pleaded having anxiety and could not remember the specifics of that. Thank you.
Mr. Martin.
Okay.
So thank you for your time. If there are no other questions, I would just respectfully ask that the board the court affirm the board's order upholding the substantiation.
All right.
Thank you.
Thank you very much. Please call the conclusion of the hearing.
The next hearing for the court is scheduled for 9:45 this morning.
Thank